Welcome everyone to the International Law Institute series on COVID-19. In this occasion, to talk about the issue of insolvency. We have a panel from the World Bank groups on finance, competitiveness, innovation, global practice. And before I introduce them, let me tell you just a little bit about our series. We have a series of webcast on a number of topics, including contracts, dispute resolution. We invite you to explore our website and the different offerings there, in addition to our regular seminars, some of them which will be available online. So with that, I'd like to start with the subject, but for that, I will introduce you to the panel. First, we have Mahesh Uttamchandani. He is the Global Manager for the Financial Inclusion and Access to Finance. He manages the bank's global work on payment and market infrastructures. He's also responsible for financial access, insolvency, and credit infrastructure. In addition to that, he's the chair of the International Committee on Credit Reporting and oversees the bank's Insolvency and Creditor Rights Task Force. Mahesh joined the bank back in 2006, and before that, he was with the European Bank for Reconstruction and Development, and he was also a litigator with a leading Canadian law firm. He has published many articles and has taught at the university level and has lectured a lot, so you're going to have a great time and learn a lot from him. We also have Nina Mosheva. She's a senior financial sector specialist in dispute resolution. Nina is a lawyer that was trained both in the civil and common law traditions. She specializes on dispute resolution schemes tailored to very specific sectors, such as insolvency, financial consumer protection, and debt resolution. Nina focuses on assisting bank member countries in improving their insolvency and debt resolution regimes, as well as implementing ADR mechanisms in those countries, such as arbitration and mediation. Before joining the bank, Nina worked in the field of international arbitration and litigation with a prominent law firm here in Washington, D.C. And finally, we also have Antonia Meneses. She is a senior financial sector specialist with the insolvency and debt resolution team with the World Bank Group. Antonia focuses on providing technical assistance and advice to governments on insolvency and debt resolution. She has worked with over 50 countries, although the majority of her work concentrates in sub-Saharan Africa, the Caribbean, and South Asia. Antonia has also published extensively in the field of insolvency, and in addition to that, she represents the bank in the working group 5 on insolvency at the UNCITRAL. Antonia is a qualified solicitor in the UK, and she, prior to joining the bank, she practiced back in Paris and in London. She holds an LLM from McGill University and also an LLB from the London School of Economics and Political Science. So with that, I pass the mic to our colleagues. So welcome.
Thank you very much, and thank you to everyone who's joining us online today. I want to thank the ILI first for inviting us here today to talk about this important topic. And I should note at the outset that the views you will hear from the three of us are our own views and do not necessarily reflect the views of the World Bank, its executive directors, or its shareholder countries. But with that being said, we want to discuss insolvency legal systems, particularly in the context of the COVID-19 crisis. And I guess I would start with a question we are often asked, which is why at the World Bank we are concerned about this topic. We've seen since the Asian financial crisis in 1999, when we were asked to take on the role, along with UNCITRAL, the UN Commission on International Trade Law, of the role as international standard setter in this area, the important role in combating responding to financial crises. We saw it in the Asian financial crisis, we saw it in the global financial crisis 10 years ago, and we anticipate that we will see it extensively now in this COVID-19 crisis. Over the last 20 years, we have become, in addition to the global standard setter, the largest provider of technical assistance to developing countries and emerging markets in the area of insolvency, legal and regulatory reform. And today, we are active in more than 40 countries in this area. So we see, because of this crisis, an unprecedented set of challenges, particularly for businesses in the private sector in emerging markets and developing countries. In ordinary times, the objective of an insolvency system is fundamentally to distinguish between those firms that are viable and those that are not. If we can move to the next slide, please. We will so fundamentally distinguish between those firms that are viable and those that are not. And the purpose of being able to do this is to allow those firms that are viable to restructure both their finances and their operations and to continue on as healthy businesses, and to take those firms that are no longer viable and to liquidate them in an efficient and orderly manner so that their assets and even their entrepreneurs can be returned to the economy to more productive use. And that's why you see that in economies that have a well-functioning insolvency system, because the system is able to make this distinction between those firms that are savable and those that are not, and then to allow the savable firms to have a chance at restructuring, you see in those economies greater dynamism in the market, more entrepreneurship, more proliferation of startups, and crucially, increased availability of credit and at a lower cost to the private sector. And we believe that's critical to the growth of the private sector, which ultimately is the primary source of job creation in emerging markets and developing economies. So this critical function, we think, is being impaired right now during the COVID crisis, and we see that challenge getting quite a bit more difficult. The COVID crisis is introducing two fundamental challenges to businesses, and that relates to the ability of the insolvency regime to function. In the immediate term, we see a liquidity crisis. Because of the lack of demand and because of the nature of the shutdowns that are going on around the world, businesses are unable to operate as normal, and that's creating what for many of them will be a temporary but still severe cash flow problem or liquidity crisis. This is resulting in an excess of firms being pushed towards the insolvency system of their countries. And in the same way that hospitals are challenged to respond to the health crisis, courts and legal systems are challenged to respond to this influx of troubled firms. And so one of the things you'll hear about today is the importance of taking immediate steps to so-called flatten the insolvency curve. But the other challenge we see is a longer-term crisis of solvency. I think there is general acceptance that this COVID crisis will fundamentally alter the nature of business in so many countries and will lead to a series of firms for various reasons that are no longer viable, either because their markets have fundamentally changed, their business models need to fundamentally change, or the goods and services that they provide are no longer in high demand in this post-COVID environment. So what we will discuss today is how we see this crisis playing out in the context of insolvency systems and how we believe countries should respond through a phased approach to get through both the immediate short-term challenges posed by this crisis and the longer-term challenges, and hopefully moving into the recovery phase. So with that said, I will turn it over to my colleague, Nina Mocheva.
Thanks, Mahesh. If we could just move over maybe to slide 4 or slide 5. Yes, thank you. Thanks a lot. So thanks, Mahesh, and thank you also from me on the invitation from the International Law Institute and for the opportunity to present our observations with respect to how the insolvency systems can play a very important role in mitigating the effects of the current crisis. As Mahesh already mentioned, many countries are vulnerable across multiple dimensions, but one of the most serious effects of the COVID-19 that we have seen is on the real sector, which makes it different from past global crises that originated in the financial sector and migrated to the real sector later. Experts and various stakeholders already conclude that the negative effects of COVID-19 on the corporate sector globally will be far greater than any other recession that we have observed in modern times. As Mahesh already mentioned, stakeholders are in agreement that we will see a surge in bankruptcies across sectors, and it's not a matter of if this is going to happen, but it's more a question of when this should be expected, so countries would have to prepare for the effects of it. In part, the expected increase in the number of bankruptcies in the near months can be explained by the limitations of many countries to provide sufficient fiscal and monetary stimulus packages as a buffer for firms during the crisis. The scattered diagram that you see on this slide displays the country's external debt stocks by region as a percentage of GNI, correlated against what we call the corporate insolvency index, which is construed as a composite measure of creditors' recovery rates, the strength of the country's insolvency legal frameworks, and the quality of the country's commercial judicial processes. As you can see from this diagram, some of the countries identified at the top of the graph with higher reliance on external debt have lesser capacity to provide the type of fiscal measures, fiscal stimulus measures that Mahesh already mentioned, and hence would have to rely more on their insolvency system, on their insolvency framework to deal with the firm distress as a result of the crisis. This reliance would be even more important during the recovery and rebuilding phase, which Antonia is going to discuss in more detail later. If we can go to the next slide, please. In addition to financial stimulus packages for the private sector, many governments have also intervened with measures related to their financial sector, such as general moratoria on the repayment of bank loans, loosening requirements for the treatment of non-performing loans, NPLs, capital and liquidity buffers with the objective of providing sufficient breathing space for distressed firms and or for allowing lending to affected firms to continue. However, as can be seen in this particular scattered plot, many countries are already at very high levels of their non-performing loan ratios to total gross loans, and introducing such measures targeting the financial sector could further exacerbate their financial stability. In fact, based on IMF data, the level of debt just before the crisis erupted was the highest ever recorded. And so intervening through measures affecting the financial sector only might negatively affect the financial stability across regions. For these countries identified at the top of the scattered plot, relief should rather be sought through the insolvency system, and this is the measures that we'll be focusing on during the rest of our presentation. If we could move one slide. Thank you. The challenge, however, is that even when properly functioning, insolvency systems in normal times, they may not offer adequate mechanisms in times of global crisis such as this one, especially a crisis such as this one, which is affecting primarily small, medium enterprises and individuals. So it's starting from the bottom up before large corporations and the financial sector is affected. Further, the insolvency regimes in many emerging markets and developing economies, which we work with, are already displaying very serious deficiencies. And this, of course, can further amplify shocks. The challenge for countries' insolvency systems at present will be to distinguish, as Mahesh mentioned, between firms which are viable but experience temporary liquidity issues and unviable firms that have to be quickly closed. Traditional insolvency regimes, even where they have worked well in normal times, may not be able to adequately address recovery during a systematic crisis, when the scramble for liquidity increases the risk of pushing viable firms into bankruptcy and asset fire sales, which of course result in serious value loss. Next slide. So for all these reasons, we have seen that countries are already taking certain measures, and we have identified and have been advocating for a phased approach when designing measures to mitigate the effect of the crisis and to address the following effects during the recovery and rebuilding phase. And those measures in the phases and the way they're sequenced have to take into consideration the specific challenges faced by countries' legal and institutional frameworks. We have identified the three phases that Mahesh already mentioned of reform, which might be considered sequential, but they might also have significant overlap, especially phase 2 and phase 3, depending on the respective country context. In phase 1, just very briefly, and we'll go over in more detail later, creditors who are themselves faced with liquidity challenges may or are expected to prematurely push viable firms into insolvency, resulting in significant value destruction. And therefore, this phase should envisage emergency measures to flatten the bankruptcy curve through temporary modifications of the regular insolvency framework. It is important to highlight and to remember that though the measures in this phase 1 should be designed as temporary and should provide for a sunset date, for a specific sunset date, because some of them might distort the balance of different stakeholder rights and in turn affect, of course, the overall financial stability. In phase 2, the recovery phase, which Antonio will talk about, the insolvency system will have to respond to the increase in both firm failure and the increase in firms that cannot restructure their debts without some sort of an out-of-court workout system or through formal reorganization processes. And finally, phase 3, which could overlap with phase 2, will require a focus largely on small and medium enterprises and individuals dealing with the aftermath of personal financial distress resulting from the crisis. Next slide, please. So the premise for the emergency measures, which many countries have actually already taken as part of their phase 1 interventions, is that due to COVID-19, policymakers around the globe fear that countless businesses will be forced to file for liquidation in court, or creditors will file for involuntary petitions. And this would affect the stability of financial markets worldwide if not processed effectively. The resulting volume of bankruptcy filings and related prolonged proceedings in court may overwhelm already busy bankruptcy courts, as has been evidenced in past crises, drawing out an already painful process. As you can see from this figure, representing the ratio of previous year's enterprise bankruptcy petitions between years 2006 and 2017 in 3 countries, the United States, Germany, and the Netherlands, there was a huge spike in court filings during the years of the past financial crisis, and especially in 2008. Many countries do not have the capacity to handle such numbers. The COVID-19 pandemic is already affecting the operation of basic institutions that deal with corporate insolvency, creating further instability. And for example, many courts and insolvency agencies in various countries that we have observed are struggling to operate, and this of course affects mostly emerging and developing markets, but not only. Many countries' court processes are less digitalized, and then some courts are also temporarily closed doors except for emergency cases. Next slide, please. So hence the objective of this phase 1 of insolvency reform interventions should focus or should attempt to flatten the bankruptcy curve and prevent the forced bankruptcy of otherwise viable firms. And the purpose of reforms in this phase should be to introduce time-bound temporary measures which may deviate from the rules of the regular insolvency regime in order to help bankrupt businesses restructure more easily. Some of the recommended measures here in this space will go beyond the best practice principles prescribed by the World Bank, insolvency and creditor debtor rights regimes principles, because by design they're extraordinary and they should only assist firms facing issues related to the COVID-19 crisis. Therefore, as I already mentioned, and will keep repeating throughout this presentation, having a sunset date is essential in order to avoid upsetting the balance of different stakeholders' rights. Some of these measures include, as you see here on this slide, limiting creditor-initiated or involuntary insolvency filings for a specific period of time, and suspending the ability suspending the director's duty to file in countries where this concept exists, and the associated personal liability for managers who don't file on time. With respect to the creditor-initiated insolvency filings, several countries have already adopted specific measures in this respect. For example, Australia has increased the monetary threshold at which creditors can issue a statutory demand on a company from 2,000 to 20,000 Australian dollars. India has also adopted already similar measures, and Armenia's parliament is currently discussing significantly increasing the monetary threshold for bankruptcy filings, both for enterprise and personal bankruptcy. Spain has altogether suspended creditors' rights to file involuntary bankruptcy petitions until the end of their state of emergency period. It is important to note here that debtors should still be encouraged to seek restructuring options, including through court, if this is feasible at the moment, and the proposed temporary limitations or suspensions should be focused on involuntary bankruptcy filings only. With respect to the temporary suspending of the duty to file, Germany is a good example, and some countries with similar provisions in their regular insolvency framework have also taken the same approach. Germany's regular insolvency law contains rigid obligations for directors to file a company for insolvency without undue delay, but no later than 3 weeks after the company has become insolvent. And these obligations to file for insolvency on the part of directors has been suspended until September of this year for now. This relief, however, does not apply if the insolvency is not a consequence of COVID-19 or if there are no prospects of eliminating the existing illiquidity of the firm. It will be assumed, according to the German emergency law, that an insolvency was caused by the effects of COVID-19 and the prospects for overcoming the existing illiquidity if the debtor was not illiquid by end of December of 2019. Next slide, please. So another measure as part of the emergency phase 1 insolvency reform package is to complement the insolvency reform measures with certain debt repayment emergency measures. Countries have adopted different types of those, and they could be grouped in 3 different categories, as you can see from the slide. From purely private initiatives, such as an agreement between banks not to pursue payment during a specific period of time, which has been the approach in the Netherlands, to emergency legislation modifying contractual terms, addressing either the prospects of repayment, for example, extending the repayment terms of a set of loans, which was the case in Portugal, or the effects of non-payment, for example, by prohibiting the acceleration of contractual terms, which is what France did. And then finally, these complementary measures could be done through judicial interventions, either through suspending judicial proceedings involving debt repayment, this was done in Italy, or through suspending the execution of certain assets owned by individuals, which was the case of Bulgaria through its State of Emergency Act. As already mentioned, these types of measures should not be envisaged as a permanent feature of the insolvency system of countries that take them, and countries should quickly start thinking about deeper structural reforms that would address enterprise distress during the recovery and rebuilding phases. And I'll hand it over to Antonia, who is going to go deeper into the phase 2 and phase 3 recommendations and the measures that we have included there. Antonia?
Thanks, Nina. Next slide, please. So, as my colleagues have said, insolvency is a state of financial distress where a business or an individual is defaulting on their debt. It can lead to an insolvency proceeding which filters firms so that either the assets and liabilities of the business are restructured and the business can continue as a going concern, or it is closed and liquidated. In the COVID-19 crisis, this core function of insolvency regimes changes because viable businesses, which might be facing temporary supply disruptions or a workforce that is social distancing, might be pushed into bankruptcy. In phase one, as Nina said, governments need to flatten the bankruptcy curve to prevent overwhelming the courts and buying time for businesses in the hopes that those that are currently in default will be able to start repaying their debts through stimulus measures or when the economy recovers. In phase two of crisis containment, even if we have flattened the curve, there will still be a large number of financially distressed corporates that are going to need the protection of insolvency frameworks. And I'm going to take you through one of the key tools for managing restructurings that aim to change a business's assets and liabilities to ensure that they can keep going with supply chains and employment largely intact. And these tools are called workout frameworks. The parameters for designing workout frameworks are set out in the World Bank Principles for Effective Insolvency and Creditor Debtor Regimes. As I'm sure some of you know, these World Bank principles, together with UNCITRAL's instrument, the Legislative Guide on Insolvency Law, together form the FSB Unified Standard and provide best practices for insolvency regimes. So on this slide, you can see that Principle B4.3 specifically states that in the context of a systemic crisis, or where corporate debt has reached systemic levels, informal rules and procedures might be needed to supplement the legislative framework and work out non-performing loans. In fact, workouts were a relatively common tool during the Asian crisis of the 90s, and they were also used extensively during the 2008-2009 financial crisis. So what are workouts? They provide an enabling framework for multiple creditors and the debtor to quickly negotiate private, contractual, and confidential restructuring arrangements. In its simplest form, the debtor business approaches each of its creditors or main creditors and negotiates terms of a restructuring plan. Creditors who agree to participate in the restructuring will receive similar treatment, but since there's no requirement for participation, creditors who not agree will not necessarily be affected by it. Some of their primary advantages are that workouts are fast compared to court procedures. In fact, the fact that it's confidential means that there is less stigma than formal insolvency processes. And the debtor's management often remains in control, which is an important advantage and incentive for the debtor to participate in this. In a crisis scenario such as COVID-19, being able to move away from the courts and save businesses quickly through private negotiations is hugely beneficial. Also, the fact that no legislation is involved is appealing to many countries. In some countries where we are working, for example, the ability for emergency legislation to be drafted and for Parliament to quickly convene is not feasible. So this provides a strong alternative. On the other hand, workouts are often voluntary processes, so getting effective restructuring agreements in place that involve all relevant creditors can be difficult, and there can be problems of creditor holdout, which can stall the process. Success often depends on creditors sharing information transparently in order to analyze the financial situation of the debtor, and depending on the culture of the country, this can be difficult. And workouts also don't deal with some of the broader public policy aspects that formal insolvency regimes deal with, such as punishing fraudulent and criminal conduct. The picture on the right of the slide is of the, next slide. The picture on the right of the slide is of the insolvency team's toolkit, which gives more information on designing workout regimes for countries. And this can be found on the website, which will be listed at the end of the presentation. Next slide. Core multi-creditor workout principles come in a variety of models. But one of the models that is most common was developed in the 1970s by the Bank of England. And some of these principles are that this was a non-statutory framework, but provided for a standstill agreement whereby banks agreed not to have a grab race and enforce their debts in order to give time to try and put a restructuring agreement in place. Secondly, banks agreed to provide information on a confidential basis, and banks worked together to reach a collective view on whether and how a company could be given a financial lifeline. However, workouts can also be more formal, particularly during systemic crises where the intervention of the state is deemed necessary. So, for example, during the Asian crisis, many workout frameworks were attached to asset management companies, such as the Korean Asset Management Company. The Istanbul approach is an example of a more formal workout framework. This was enacted by a banking law in 2002 and provides for an inter-creditor agreement between banks and a creditors committee, as well as an arbitration panel that can cram down or impose the plan on minority creditors with certain safeguards in place. One of the most important aspects of rescue is financing. Often distressed businesses will not survive unless they have additional financing available. An effective way to encourage this type of lending is to accord priority status to repayment of such funding with the agreement of the other creditors, which reflects the additional risk that creditors providing this financing are taken. And what we're seeing during the COVID-19 crisis is that a number of countries are bridging short-term financial distress with specific lending schemes. Next slide, please. Alongside workouts, some businesses will need to go through the formal reorganization process, either because creditors have commenced proceedings or because they need safeguards provided for in the system. As with the measures discussed in phase one, a lot of policy responses here are focused on trying to ease the burden on both the debtors and the courts. So for example, deadlines are being extended for a limited period of time. Countries like Bulgaria have suspended all procedural deadlines for ongoing court litigations and executions. Countries that have weak reorganization frameworks need to ensure that they're reformed and operating well in practice. And this is going to be a test for many countries that do not have a strong restructuring culture. For instance, in some of the countries where we're working, we're seeing that even though some of the largest corporates are currently undergoing formal restructuring, there's not necessarily a strong restructuring culture amongst the stakeholders, and this is causing difficulties. Finally, going back to a point that Nina raised, a concern that spans many areas of commercial law, not just insolvency, is that the courts are going to be inundated with cases. And we're seeing that many countries are already starting to equip their courts with increased numbers of staff and move to virtual hearings and try and leverage other types of technology. Next slide, please. Phase 3 of the crisis is addressing MSMEs and individual household insolvency. And on this slide, you'll see that there is a new note referenced by our colleagues in DEC, which aims to estimate how long firms can survive when there is a lockdown using enterprise survey data. The note uses data for 12 countries and shows that the median survival time of firms under lockdown, where sales drop to 0 across industries, ranges from 8 to 19 weeks, with retail being the lowest, while on average firms have liquidity to survive between 12 and 38 weeks. A new OECD SME policy response document uses commercial court data in France and shows that 72% of companies that have less than 5 workers and 51% of companies with a turnover of under 500,000 euro are now at grave risk of financial collapse. Two main policy responses that will alleviate pressure off MSMEs and individuals are ensuring that there are flexible options for debt rescheduling and repayment plans. Informal, out-of-court administrative processes will help minimize stigma and make it more affordable for these businesses. And ensuring that there is a modern individual household bankruptcy framework in place will provide debtors with key protections. In particular, a good bankruptcy framework will allow for a fresh start or discharge. So for micro and small businesses, this will allow a measure of debt forgiveness with specific safeguards and parameters in place, which will then allow them to enter the economy and not carry a debt burden for life. Next slide. The importance of MSME insolvency reform work should not be underestimated. Several commentators are talking about this crisis as being a bottom-up crisis, whereby we're seeing MSMEs being more affected, at least at this stage, more extensively than corporates. And the World Bank Group is working on developing core principles or benchmarks in our standards that will help address this point. Next slide. Once the crisis is contained, the next phase of work will be recovery and rebuilding the economy. The issue is that even if we have done everything right in terms of flattening the bankruptcy curve, it's possible that there could still be a second wave of insolvencies. And indeed, a number of individuals are forecasting that in a couple of months, when stimulus measures have finished, we will see a wave of insolvencies. Going back to Nina's initial slides, in the recovery phase, we need to see the insolvency regime returning to playing its market efficiency role, restructuring viable businesses and liquidating non-viable businesses. However, the system will be strained. Institutions such as courts and regulators will be overburdened, and zombie firms that were non-viable before the crisis will now need to quickly exit the market, freeing resources for new enterprises. The World Bank principles can assist in strengthening both the institutions and the legislative framework. As we have seen in previous crises, if the framework is weak, creditor recovery is lower, and access to credit remains constrained. Next slide, please. So to summarize, we have put forward 3 phases of crisis containment. In phase 1, policy measures will focus on preventing viable firms from prematurely being pushed into insolvency, such as implementing extraordinary measures for a limited period of time, which might increase the barriers for creditor-initiated insolvency filings or suspend the director's duty to file. In phase 2, policy measures need to respond to the increased number of firms that will not survive the crisis without being restructured, including putting robust workout and restructuring frameworks in place and facilitating access to finance. In phase 3, policy measures need to address individual household distress and micro and small business distress through a modern personal bankruptcy framework. Following this, the focus needs to be on rebuilding the economy, including through more efficient and effective insolvency regimes. Next slide. The World Bank Group, together with Insol International, have developed a reform tracker, which currently outlines emergency measures in 45 countries, as you can see on this map. You can access this tracker on the website listed here, and also on the same website, you'll find several other papers published by ourselves and other teams related to the COVID-19 crisis. And we will continue updating this website with additional information and papers that you might find helpful. So we would like to thank you all for listening to this. We hope that you found it useful and interesting. And please, if you have any questions, do not hesitate to contact the team for further information.